In which circumstances can a review be granted? The provisions relating to review are contained in Section 114 and Order 47 Rule 1 of the Code of Civil Procedure 1908. A review is a remedy by which a person aggrieved by a decree or order may apply to the same court that passed the decree or order for reconsideration of its decision. A review may be granted in the following circumstances: discovery of new and important matter or evidence. A review may be granted when the applicant discovers new and important evidence which, despite exercising due diligence, was not within his knowledge or could not be produced at the time when the decree was passed or the order was made. The newly discovered evidence must be material and of such a nature that it may affect or alter the judgment. Error apparent on the face of the record. A review may be granted where there is a clear and obvious mistake or errors apparent on the face of the record. Such an error may relate to a question of law, a question of fact, or a procedural irregularity. The error must be self evident and should not require a lengthy process of reasoning to establish it. Any other sufficient reason. A review may also be granted for any other sufficient reason. However, in Chajju Ram versus Neki 49 IA 144, the Privy Council held that the expression any other sufficient reason must be interpreted to mean a reason analogous to the grounds specifically mentioned in the rule. Object of review. The purpose of review is to correct a patent error and prevent miscarriage of justice. It is not intended to enable the court to write a second judgment, to rehear the case on merits, to give a dissatisfied party a fresh opportunity to argue the case. In Meera Bhanja versus Nirmala Kumari Choudhury, AIR 1995 SC 455, the Supreme Court observed that the power of review is not intended to provide a second innings to a party who has lost the case because of negligence or indifferences. Conclusion. Thus, under Section 114 and Order 47 Rule 1 of the Code of Civil Procedure 1908, a review may be granted on the discovery of new and important evidence, an error apparent on the face of the record, or any other sufficient reason analogous to these grounds. The remedy of review is limited in scope and cannot be used as a substitute for an appeal.